section or at the preamble?
I think that's a good idea because it could impact the preamble language.
Sure.
All right. On page 2. So on the number 1, did we have any comments on number 1?
I'm not sure whether this is a comment on number 1 or elsewhere, but as my short comment reflected, this is generally speaking a recommendation to Congress, which is entirely appropriate. One of the considerations that Congress needs to have in mind is the constitutional expectation that it will retain control through the power of the purse over government actors. And that possibility is consigned to an obscure footnote, number 6 in the preamble, and I think that's simply inadequate. One could say it is a general consideration for Congress in thinking about this issue to consider the extent to which maintaining control of government action through budgetary controls is an important factor.
No, thank you. Oh, thank you, Peter. Sid, are you responding to Peter's comment, or you have a different one?
I have a different one.
Okay, so I'll pause for a second to see if Erica or anyone else has thoughts on Peter's astute observation.
Well, again, I mean, I think I agree completely. I would say that from my perspective, when I did the RFP, ACUS explicitly asked me not to address those issues. And so that there's sort of discussion in the report, but I didn't include anything like that in my report. But of course, that's my report. And the recommendation, it's up to the committee really, and ACUS ultimately what they want. And I think the notion that one of the recommendations for Congress should be consideration of that issue, I think is entirely appropriate.
Okay, I'm sorry, Dave or Jeremy, I didn't see who put their hand up first because I was reading the text. So Dave?
Certainly. Just in terms of my statement that I agree with Peter, I'm focusing on the first half of the footnote with regards to does not address whether agencies may or should draw on user fee receipts absent congressional authorization or outside the process for congressional appropriations. Because in my mind, that speaks to congressional design of the user fees. And if there are situations in which that is a question, then that is something that Congress should be considering directly in its design of future programs. I can certainly understand the desire not to engage in a constitutional colloquy in a recommendation, but to the extent that there are controversies that come out of a practice, it is something that I think the ACUS can address through recommendation.
Okay, thank you. Jeremy?
Yeah, thanks, Helen. From the ACUS perspective, in structuring this project, these are obviously very live constitutional questions. We worked with the council to arrive at a scope of a project that we felt was appropriate for ACUS at this time, given ACUS's statutory mission and the fact that you have very live constitutional questions. I think the way Dave framed it is probably exactly right. I think probably engaging in a constitutional colloquy is difficult in the setting and probably beyond the scope of this project as approved by the council. Obviously, general considerations matter, and I think that's proper to flag them. We tried to flag them in 6, but there might be a more artful way to do that.
Thank you. Peter?
Well, I think there's a recommendation 1 is about general considerations. And this is a general consideration. And it should be in recommendation 1. We don't need to tell Congress what to do. And I agree that that's outside the scope of the study and raises all kinds of issues but to have this recommendation without recognition in the general considerations that this is one seems to me simply a terrible mistake.
Peter, what kind of language would you recommend for number one?
Finally, at the end,
Mhm.
finally, Congress should consider the extent to which control over government action through the budgetary process bears on its judgment. On its judgment,
On its
not on
judgment.
history.
Okay. No, thank you. I think that helps us kind of frame it.
Judgment. Final word is judgment.
Erica?
I was tracking your sentence until the very end, and I'm not sure I understand what bears on its judgment means in this. I don't understand the end of the sentence. I may be unique in that, but I was tracking till the end and then I didn't understand.
Peter?
Bears on its judgment is an element of its consideration. I mean, it's bears is, you know, is relevant to its consideration.
Okay.
What if I might suggest like another idea, what we're getting at is whether they should consider the appropriation is in the authorizing statute itself, or if it's subject to the availability of appropriations provided in annual appropriations acts. Is that what you're getting to, Peter?
No, although that's one of the ways that is directing the money into the general fund rather than leaving it for the CFPB or the Fed, which are the two settings where this issue has really been lively, is one way of retaining control. But I take it that we aren't telling them how to retain control, and I don't wish to do that. What I do wish to do is to identify as a general consideration the constitutional expectation that Congress will retain control over government action through the budgetary process.
How about it bears on its judgment for the program design?
Fine.
Erica?
I was going to suggest, I was going to suggest a shorter approach, which is just to say, finally, Congress should consider the extent to which it should, or perhaps it must, maintain control over government action through the budgetary process.
Fine.
That flags it, and without actually answering the question, without taking a position on how much it should.
Don't want to answer the question?
Yeah.
I'm happy not to answer the question. I understand it's not a part of your wasn't a part of your charge, and I think I understand why ACUS decided not to make it a part of your charge.
Yeah.
But as long as it's flagged, I'm happy.
Yeah.
Great. No, thank you. Anyone have any other thoughts on the edit? Jeff?
I'm fine with adding something like this. I just think the word must kind of
Should would be fine.
Should?
or needs to or
Should works.
it does sort of come down in favor of doing it. But the extent to which.
Yes.
So well, I know you're trying not to answer the question, but I think you're sort of putting a little bit of a thumb on the scale
The
against.
Constitution puts the thumb on the scale, not me.
And if I might suggest it, I'm not sure it does fully put a thumb on the scale, because one of the things we've talked about and one of the things the report talks about is non-constitutional reasons why Congress might want to maintain that control. So as long as we consider the possibility that it could be motivated by reasons other than constitutional reasons, I think that that means it's not not inherently putting a thumb on the scale with respect to the constitutional question.
Fine, and the word constitution doesn't appear here, it doesn't need
Yeah.
to.
Yeah, no, thank you. Dave, I see your hand.
Yeah, one of the things that I struggled with in this and the conversation about the constitutional parameters was someplace that I do think ACUS has a role, and that is the issue of, for lack of a better term, political legitimacy and accountability. I don't know if perhaps I might have accidentally deleted my own comment. But later on, one of the factors that I think it's legitimate for Congress to address in its design is accountability. And so I wonder if a way of approaching this question of should they or shouldn't they in a constitutional manner might be approached in a way of saying, regardless of how Congress decides to approach it, or regardless of how the constitutional issues are, Congress should always be considering accountability for the use of taxpayer funds in its design of user fees.
Okay, thinking of how we can add that concept in there. So should that be more in the section that's for Congress? Because this is the general one. And not that I'm saying that agencies would think that they shouldn't have to be accountable, but when we're thinking of the design, should that be included in the section that's specifically for Congress program designers?
Yeah,
I mean, when I originally considered it, yes, I was thinking of it in terms of, how should Congress develop a new user fee program? But when we talk about the question of what does the Constitution allow and not allow, from a good government point of view, it's really a question of how do we maintain political legitimacy of the use of taxpayer funds, and accountability may be a general principle that can provide that sort of balance against the question of can they or can't they, under our structure of government.
I wouldn't mind, should maintain accountability for instead of control over. No, back.
Right, so instead of control over government action,
It would be accountability for government action through the budgetary process. And specifications about the use of taxpayer funds or anything else you might choose to put in there.
Maybe can we just simplify it to say maintain accountability for the use of taxpayer funds?
I really want a reference to the budgetary process.
Okay. I certainly don't have a objection.
Okay. I see Jeffrey and then Erica.
So I'm going to make another stab at this. It still seems to me that it's a statement that would lead people to say it's better to use the appropriations process than to use user fees, because Congress would always say we should maintain accountability over government action. When you compare this to the objectives provision in Circular 825, it says it is the objective of the US government to ensure that each service, sale, and use of government goods or resources is provided, to be self-sustaining. There's language in favor of user fees in our current 825. I'm not necessarily saying that I love user fees in every situation, but I mean, I think this statement I read as be very cautious if you before you create a user fee. Because there's a general need for accountability and using the budgetary
Before you
process.
create a user fee that does not go into the general fund. You could create user fees, and you could create user fees that meet the consideration that you have in mind, that wind up, in fact, providing the government with the money that is required to run the particular program, that redress that capture the benefits to those who are involved in the program in the way that ACUS expects. But to talk about financing through user fees does not answer the question about where the money goes. And again, to go back to the really vigorous, and it seems to me appropriate, debates about the Fed and the CFPB, that's where the rubber hit the road.
But this number one, or maybe this section of the recommendation doesn't really address where the money's going and the different types of user fees, those that go to the Treasury and those that go for the agency's use. There may be a very important distinction between those two types of user fees, but this last sentence that we've added doesn't parse that. So I mean, I don't think we want to put, well.
No, I see where you're going. Sid, are you jumping in to help out? Oh, you're on mute.
Sorry about that. I wonder if it would help if we use the word how. Congress should consider how it should maintain.
Over government action, comma,
Yeah,
as
yeah, the
through
rest stays the same, yeah.
comma, as through the budgetary process or
Okay.
specifications on the use. That's okay.
Maybe that takes the thumb off the scale a little less, as Jeff is perceiving anyway, or some might perceive.
If I can respond, I think that helps. Although, is it specifications on the use of taxpayer funds or specification on the use of both taxpayer funds and money collected through the user fees?
Yeah, it's the money's collected through the user fees, huh?
Fine.
All right, anyone else have any thoughts on the language?
I like that.
Any objections from anyone? Nice collaborative effort, finding some good language, everyone. Then are we moving on to number 2 or comments? Because I don't see, it's hard to see the comments as I look at everybody too. So call out the comments for me as we do this too.
So the other comments here are all for the preamble.
Okay, okay, perfect.
I have
Oh, go, yes, please.
I've got a comment on one, if we're
Oh,
still there.
thanks, Sid. Yep, let's stay on one for the.
Yeah, so it now reads, I'm in the first sentence. Such as shifting the costs of a program from taxpayers to those persons or entities whom the program benefits most directly. And my question is about the words most directly. Aren't we instructing Congress when and when not it's supposed to use user fees? Maybe Congress wants to have people pay who benefit generally. I don't know, but that may be based on case law or something I missed in the report. And if so, I withdraw my suggestion, but otherwise, I might eliminate those words.
Okay, Erica?
No, I think that's fine. Deleting those words. I mean, this was meant to be a such as, I think. I assume that's what Kaja and Jeremy meant, but I think getting rid of most directly makes sense.
I'm seeing nodding from Kaja, so thank you for that catch, Sid.
Yeah.
Excellent. Anyone else on 1 before we go to 2? Going once, going twice. Let's go to number 2 then. Does anyone have any, because I have one, but I'll wait to see if everyone else has any other comments first. Okay, so my one was on when we start saying conflict of interest. Oh, sorry, Jeffrey, you can go first though. You're on mute. Sorry.
Muted, you're muted, you're muted.
I'm sorry. I was wondering about the word inadvertently. I mean.
Yeah.
Do we need that?
I don't think so. Does
No.
anyone feel strongly about the word inadvertently? No, I think we can take it out. Thank you. I was focusing on, we say conflict of interest, and that's a term of art in like the ethics world for government. And I didn't know if when this was drafted, if we were thinking of like the ethics world of conflict of interest, or are we thinking more of like impartiality? So I wanted to check in on that.
I'll just say, I have my hand up and I'm not muted, so I'm going to go ahead, take the consultant's prerogative here to say that it came up in some conversations that I had, interviews, but it was never meant in the government ethics sense. It was meant more as a sort of a general sense that it was a reference frequently to what I think this group would refer to as capture, rather than conflict of interest in, the 18 USC sense. I assume that Jeremy and Kaja wrote conflict of interest meaning the same thing as what those people had meant.
That's helpful. Peter, did you have
Would it help, instead of saying conflict of interest, if that pushes the wrong button, to say such as creating an inappropriate incentive for the agency?
Yeah.
How do other people feel about that? Any heartburn? If we like this language, I think we'll have to copy and paste in a couple of other sections of the document too, where we use conflict of interest. Thank you, Peter. Dave.
I'm just, honestly, why I'm uncomfortable with the word incentive there, leaving unspoken an incentive to do what?
What?
And I'm wondering if it might just be easier to say, where it said inadvertently, to say inappropriately affect agency decision-making, and then strike the second clause.
Okay, there we go. Does that lose anything else that anyone's worried about? I think that's an elegant Steph.
The word
I
making
wonder-
needs to go also.
Yeah.
After decision, the word making needs to go.
Are we concerned about losing the perception?
Yes.
So it's
That
like,
is actually something that was raised. Yeah, the perception of it is a separate issue.
so is
yeah.
that it could create the appearance of impartiality? Is that what we're getting at?
Well,
I think it
speaking
has
from
to
the
be both.
Oh, sorry.
Would it be inappropriately affect or be perceived as creating? As affecting agency decision making?
There we go. Might inappropriately affect or be perceived as affecting. Yeah.
Steph likes it. And did you have another comment, Steph?
No, that was it.
Thank you. That seems like an elegant solution. How does everyone else feel about it? Any concern? Jeff?
Yeah, I like this. It relates to a concern I was going to raise maybe towards the end of our discussion today, but I was talking with a colleague here who works with on immigration issues, and he was asking me about user fees because, you know, CIS uses them a lot, as Erica's report mentions. And he was suggesting that in some situations, the fees were kind of outlandish, or, you know, they were charging the same fee over and over again, even though it only should have been charged once, or they were charging, you know, Afghans a big fee, but not the Ukrainians a big fee at all for certain things. And he's just raising a lot of issues that he saw with the program. I don't know if they're true or not, but we don't really say anything about the and he was insinuating that, or implying that the agency was basically just trying to raise funds for its operations. And Erica did point out that that agency is basically a fee-based funded agency. But I just wonder if we can say anything more about, you know, agencies shouldn't just kind of set fees that are inordinate, that in order to basically fund itself. I mean, it's different from affecting agency decision making. It's different from even a conflict of interest. It's more sort of taking advantage of fees, or of fee payers in a way. And I don't have language, but I just thought it was a concern. I was going to tell him about our recommendation, but then I couldn't find anything that would assuage his concerns about what he was talking about. So maybe, I don't know if this is the place to raise it. I mean, it seems like it might be, but at some point in this recommendation, I think it would be good if we could say that agencies shouldn't do that.
Well, you set off a lot of hand raising, Jeff, so I think people have some thoughts about this one. Sid, I think I saw your hand go up first. And it looks like you're on mute.
Sorry about that. We do talk about it, but not with regard to agencies, but with concerning Congress in subsection B, whether reducing or eliminating fees for certain users would promote equity, and on and on there. But that's for Congress setting up the program.
But that's
Jeff's point is how the agency administers it, which is different.
right.
Yeah. All right. And
Part of it was equity, like the Ukrainians versus Afghans, and part of it was just charging too much too often for in an unnecessary way.
yeah. No. Let's keep this going. So Carrie?
I had a comment going back to number 2. I wonder if we might add another inappropriately after, or be perceived as inappropriately affecting. There might be another way to edit it to use one, but it seemed to me that the concept applied to both affecting or the perception.
Okay. Anyone have an issue with that edit? If not, thank you, Carrie, for that catch. And then let's go back to Jeff's idea concern. Erica, in the report, did you cover this? Was it one of the concerns that was raised in your report about how agencies might, especially if they're using it to fund themselves, the fees that they set could be, they could be impacted by knowing that they're filling their coffers by doing this?
Yes, I think it comes up in several places in the report. One of the issues that was raised was even with the budgetary process. If it's going to be entirely self-funded, the concern that there's an incentive to overstate anticipated costs, and an under incentive to restrain expenditures. And that was one of the reasons for the suggestion in my report that there be some transparency and stakeholder involvement even during the budget formulation process for an agency that is entirely self-funded. So absolutely, this comes up.
Maybe Peter's incentive language could be restored somehow.
Would this be more effective be in the considerations for Congress? As they're designing it, like what type of like bumpers they're putting up so that way agencies don't misuse this, Sid? Or Dave, did you
I
have your
was going
pencil? Sorry.
to suggest we make them parallel. So in 2, we have inadvertently, if I'm reading from the old language, inadvertently affect agency action, take out the or, and then be perceived as, we have the next clause, and then put a comma, or raise issues of equity. And then we say, and then if you want to make it parallel to Congress, raise issues of equity, barriers to market entry, incentivize desirable behavior, or produce some other socially beneficial outcome. You'd have to fix the language, but you could raise the same set of considerations. So in other words, agencies within their authority should consider those factors, and Congress, when it designs a program, should consider those factors.
I like that. Dave? Sorry, I missed you earlier.
Oh, quite all right. I mean, with regards to Jeff's issue, not necessarily as one of equity, but of one of an agency being overly aggressive in its user fees in order to supplement its overall budget. I think we have 2 different issues. I mean, one is the issue of congressional design, because Congress has given an agency authority to use the funds that it gathers. And so I think that is appropriately put with the recommendation about how Congress designs. And it goes back to the, what I mentioned before as accountability. Congress needs to be designing in functions of accountability when it gives agencies this discretion. The more challenging one is, what do we tell the agencies? What is the principle that we want agencies to consider when we say, don't charge too much, you shouldn't be spending so much money, you agency, even though you have the authority to spend what you gather. And that's a little bit more difficult in a general sense. I mean, are we, do we have a recommendation that says agencies should be frugal with the money that they gather? So I'm tempted to really put the onus on Congress here as one of design and accountability.
Design and oversight, maybe.
Exactly.
Okay. So is there more language you might suggest we could have on oversight in here?
I think we're really at that point looking into recommendation 4 as what we encourage Congress to be designing into their user fee programs prospectively.
Okay, thanks. Steph, I see your hand went up. Do you have a thought on this?
I really liked pulling the parallel language of equity, reduce barriers to market entry up, but instead of putting it into 2, I would put it into 3, which is where we sort of consider other effects. To me, 2 seem to be about, inappropriately affecting, or the perception that the agency was biased in setting these fees. And then some of these others, like promotion of equity, seem to be in the social bucket that is already tackled in 3. So I fold that into 3 as opposed to having it in 2. And then, I understand Jeff's concerns and I agree with it. And I wonder, like, commensurability is the sort of concept in my mind, or the language that I might use to discuss it. And, I think it would either be in 3 or perhaps standalone. But I think that's the basic concept we're driving at, is like user fee should be commensurate to the purpose.
Nice thought.
Measure it with the service of serves. Something like that.
And Erica, I think that kind of goes in line with what's in your report, right? Like not inflating the fee.
It does.
User fees should be commensurate.
Although I have to say this is very close to some of the guidance that's given about calculating the amount of the user fee, and whether it is measured by the benefit to the payer of the service or the cost to the government of providing the service. And I don't know how people will read commensurate with their purpose, if that will be inferred as instruction about how exactly what they should be based on, which of those, for instance, they should be based on.
The circular 825 does have a section
Yes.
called under general policy 2, determining the amount of user charges to assess. And then it's
Right.
got 4 subparagraphs there.
But of course, that's just for user fees pursuant to the IOAA, right? And these are recommendations are also to Congress for other user fee programs.
Right.
I don't know how people will interpret should be commensurate with their purpose, what precisely that would conveys. Is the goal of that to say something about how they should be calculated? What they should be based on exactly?
And that's kind of capturing what's in now 5A, but with 4A, like for the calculation of, like, are we
Well,
giving?
5A is Congress should decide among all these various ways of doing it.
Are we any better off if we use the word consistent rather than commensurate?
I guess I still don't understand though. What would be an example of one that is consistent with its purpose and one that's not? I just don't understand what exactly it means.
It would be consistent if it was sufficient to recover the full cost to the government of providing the service, resource, or good.
Okay.
I mean, that's the language from the.
So it's about cost recovery. We're trying to say user fees should be calculated as to achieve cost recovery.
This is Steph. That is not exactly what I was trying to say, although I think that is the official OMB position for certain user fees. I was really trying to say that they shouldn't be disproportionate or in excess of, we shouldn't be treating these as revenue generated necessarily. Or if we are, Congress should have clearly authorized that. So, what I was trying to say here was in this recommendation to the agency that, like, you agency should set it in this way, but you agency should look at the purpose as articulated by Congress, and then you shouldn't be doing more than that with the user fee, if that makes sense. So I think Jeff's immigration example was a real world one where, you know, there was a proposal to have user fees that would cover non, like in the visa context, that would cover
Biometric.
non-visa activities. And so, you know, that's just an example. And if Congress wants that, you know, so be it. But if they don't, then certainly it seems like the agency or the program designer shouldn't be going beyond that.
Yeah.
I mean, I can be a little more
That's helpful.
specific about the example. It was something relating to biometrics where the application would be taken in and the person would have to give fingerprints and maybe an eye scan or whatever, and that there'd be a cost for that, $80-some. But then when the person filed the supplemental application, they got charged 80. They were being told you don't have to come back in and do it again because we have your information, but they still charge the same $84 fee.
Yeah.
And
Yeah. Yeah, no. Peter, do you have some thoughts on the language?
Well, there is another side to this, I suppose, which is the situation in which the benefit to the person being charged, the fee exceeds the cost to the government. And do we wish to exclude that? One, it's not generally thought of as a user fee, but one thing that I have in mind are oil leases. The government gets quite a bit more for leasing oil drilling rights than any cost that it encounters,
well,
and because it's beneficial to that user. You know, whether we're going to call that a user fee or not, I suppose, could be debated.
that's like auctioning the spectrum.
Yeah.
Yes.
That to me doesn't seem like a user fee. It seems like a sale.
Right, but that's considered a user fee because it is providing something of it's a public good, right? Spectrum, but it's a benefit that is being doled out.
But
Right.
So it's kind of getting a little clarity here for Jeff, what you brought up. So it's the user fee should be tied to their purpose and not disproportionate to it, to Steph's kind of clarification. Is that what we're getting closer to?
I think so. I mean, I'm not trying to include sale of government property or things like that, auctions and that sort of thing. I mean, obviously the market would bear on that. But I like something like we have in the proposed 4 now.
What would be the harm in saying not disproportionate to benefits or to the cost to government costs or to benefits received? Or to benefits received would not permit ICE to go after immigration folks for multiple times.
Received, not perceived.
Yes, received.
Yeah, something like that.
Should not be disproportionate.
Mm-hmm.
So take out the commensurate, yeah.
Makes the point anyway.
Yeah.
All right, that I like elegant solutions. Does anyone else have any concerns with it or thoughts? If not, okay, thank you everyone for finding consensus on this. I guess we can go down to number 5. Are we moving to considerations for Congress then? The old 4, the new 5? Is this?
Yes, and there were some comments by Dave Rosker on these.
Dave, do you want to pop up on your comments?
Yeah, certainly. I sort of editorial in that the clause separate from the Independent Offices Appropriations Act. Since this is saying when Congress enacts a specific statute, I see that as prospective, thus not making necessary to make reference to a statute that has already been enacted.
Mhm.
And that is to say, if Congress does decide to amend the Independent Offices Appropriation Act with respect to user fees, I think we would want the recommendations to be considered as part of that amendment process. So I suggest striking the clause separate from Independent Offices Appropriations Act.
Do you want to get rid of this, or do you want to add or amends the IOAA?
I would just say when Congress enacts a specific statute, I think that's sufficient. It covers the situation. If it ever comes up, then they will have enacted a specific statute with regards to that issue.
You could say enacts or amends.
Enacts or amends, yes.
Okay, anyone have any thoughts on that?
I wonder if the IOAA would in fact be captured by this now, only because the reference to a specific statute authorizing an agency to collect user fees could be interpreted as a reference to things like the FDA statutory user fees. In other words, agency-specific statutory authority. And so if that's how the recommendation would be read, it's not clear to me that it applies to the IOAA in the
Why do we
future.
need specific?
So yeah, what if it amends a statute authorizing an agency, and you could do it with the parens for plurals? Oh, I see so many hands went up and I lost the whose was first? It was Steph or Jeremy? Steph?
I just want to, I'm only hesitating here because I just want to be sure what the sense of the committee is the committee's intent that all of these changes should also be made in the context of the Independent Offices Appropriation Act. And I would just like to make sure that that's the committee's intent before the change is made.
It would be a huge change to very general language that's been part of the US Code for more than 50 years, with a fair amount of guidance in place and court cases interpreting it and so forth.
Certainly, no doubt. I think if Congress were to reopen that statute, bringing along all of the complications that you mentioned, it would seem that the ACUS recommendations would be equally applicable to that kind of generalized statute on user fees as it would be to each individual specific program.
I'm going to suggest that make this in general plural when Congress enacts or amends statutes authorizing agencies.
Okay, and to Steph's point, and how does the committee feel about, like, has this been our intent to carve out the Independent Office Appropriations Act, or is our intent to been to include it in these recommendations?
Could I make one suggestion before people answer that? It might be worth considering the alternative of when Congress does this, it should consider specifying. And that might be sufficient to leave open the possibility that people will decide the IOAA is just fine as is. So that might be something to consider.
Where would you put that, Erica?
It should consider specifying.
Oh,
And
there we go.
that just for people to consider.
Steph?
Yeah, I mean, I guess my question is here, especially for the IOAA, is there a problem that these recommendations is fixing? And, do we have research indicating that these are the solutions? I feel like we've moved a little beyond what I understood the scope to be. And it's not that I'm trying to raise a substantive concern with this. I'm really not. It's just, I feel a little over my skis and I'd want to think about it and really
No, no.
understand the implications.
It's a good flag. Erica? Was your research really kind of focused on thinking about if the IOA is deficient in
no,
these
it did-
areas and needed to really cover them?
No,
I defer to the committee's intent. It seemed to me that that it was an exclusion that wasn't necessarily presaged in the preamble.
Mm.
And thus it didn't seem, I didn't completely understand that the intent might have been to exclude that statute. So I would defer to the committee.
Would it help if we had maybe a clarifying, like maybe if the preamble needs to clarify that the IOAA isn't really part of this? We can, yeah, okay. We'll flag that to add in the upper language. Jeff, I see your hands up.
Yes, I just think adding consider on line 79 kind of clashes with the other paragraphs because they're all phrased as Congress should,
Yeah.
So I
okay,
don't-
fair enough.
So if we go back to the original language where we
Back to the
keep
original
it
line.
It says
separate.
as
Yeah.
applicable.
Yeah.
Fair enough.
So then we would put back in the language that keeps separate from the IOAA.
Just
Yeah.
delete all
Go
the
back,
changes.
delete all the changes. All right, we'll go back to the way it looked. Thank you. All right, Dave, what else do you have for us?
Well, this was again stylistic in that the recommendation is led by, it should specify, and then we had Congress should determine whether it is preferable to specify, and it seemed like that didn't quite make sense. So my edits here are to strike all of the preferables because presumably Congress is specifying it. They've determined whether or not it's preferable. If the committee's intent is for the Congress to be evaluating these things as it writes the statute, then we would need to say something other than it should specify in the lead-in.
All right, I'm looking to our either Erica or Jeremy or Kasia. What was our intent here?
I think this is fine. I think it essentially means the same with our intent that we initially wrote.
Okay,
Wonder if you want the word either. Because we're not saying Congress should either determine the amount of the fee with or without adjustment for inflation or formula for calculating it, or give the agency discretion to determine the appropriate fee.
No, the either should come before the word determine, I think. Either determine or give.
Yeah.
that's a good call. Anyone have any other thoughts on the edits in A? All right, if not, then we can go to B. I think that's where your next comment goes, is right?
Yep. Yeah, I think the language that was distributed was persons. I'm not even sure that users is a particularly, even though it is a user fee, I think regulated entities wouldn't necessarily see themselves as users. I think it still goes back to the more unwieldy people from whom you're getting money, or entities from whom you are getting money. And it may be that we just need to develop and use a consistent shorthand. Because what I was noting here was that we had persons, people, and individuals used at various points, sometimes meant to include entities like small businesses and sometimes not. So that was the point of that.
We do
comment.
like to be consistent. So Jeff, I see you put your hand up.
On a different point.
Oh, okay, so hold on. Karen, were you on this point or a different point?
Different point, thanks.
Oh, okay. Anyone have any firm thoughts or ideas on which is the term we should be using here? Oh,
The only thing I would say is that I think it's important that it not be payers, because the rest of the sentence flags considerations that might involve actually exempting this entity or person, if you will, from having to pay. So you really are trying to get at all the people who fall in the category, I mean, users, although I understand the point about regulated entities not viewing themselves that way.
mhm.
It has to be all the people or entities who are deriving the benefit from a service or good, which is not what you should put there, obviously.
Okay, so people are, okay, well, this might take a little bit of time to think about. Everybody can, let's think about the term while we see what Jeff has to say on his side.
Mine's even more minor. I think the word conversely is not right there on 87. Because I think mayor must not charge a fee is pretty similar to mayor must waive or reduce the fee. So I'd say relatedly maybe, but conversely, it's not the opposite.
If I can jump in, since I was going to raise the same point,
Mhm.
the alternative to that is the word not in line 86 supposed to be there? Because if the word not goes away, then it is converse. So I wasn't sure which way it was supposed to go.
Ah, drafters, what?
Oh.
I think it reads better with the not taken out and then the
Yeah, I think
conversely put in.
I think we edited this last time and this was probably a red line error, but good catch, Karen. Thank you.
All right. And then we would put conversely back in then?
Yes.
Perfect. Sid, I see your hands up.
I'm back to the user problem. Can't we
Thank
just
you.
eliminate the word from all users? And then later on from specific users or something? The sentence still makes sense.
To collect the same fee or alternative, whether or not,
For certain users, yeah.
yeah.
I think that there's an element that is lost of different treatment for different users or different regulated entities. For example, we've got a fee under TSCA where Congress says you're supposed to give a rebate for small businesses. And then, so the question, and that's on top of a requirement to essentially match agency costs. So they have to rebalance on a regular basis. And so eliminating the for certain users, even though I still not liking the term users, I think it misses the idea that you are treating different people differently. And even though you're treating them differently, that can still promote equity.
So above, we use the terms individuals or entities on, like, I think that was the three ways. Program designers should consider whether a fee should have a negative or beneficial effect on the behavior of individuals or entities subject to the fee.
Not subject to the fee because.
Yeah, but if individual or entities, like looking to try to create consistency in language, is that what we want to use? And Jeff, I see your hand went up.
My hand just went up because I think we might need to put in it is preferable back in because it sounds like Congress is collecting the fee. Congress to determine whether
Oh, we are right. Oh.
Well, then Congress determine whether to require the same fee.
That's a good. All right, does that get at your, what you were thinking, Dave?
Yes.
How do people feel about this?
Well, this assumes, seems to assume that fees are either fixed at a given level or reduced from that fixed level. And again, I think there are circumstances in which the benefits to users vary, and the fee consequently can be, without regard to the equitable circumstances that are appropriately dealt with here, or barriers to market entry or the like, the fees can appropriately be higher over here than they are over there.
Could that be fixed simply by, rather than saying requiring the same fee, refer to the rate instead? Because I mean, a good example of when that would happen is if the fee is assessed at an hourly rate and different users incur different fee obligations as a result, but the rate is still the same.
I
appreciate what Peter's saying. It's we're trying to capture every possible fee design and every possible rebate situation in a simple paragraph.
How about just leaving out the require the same fee idea, because this is all about the appropriateness of reduction, and saying Congress should determine whether it is appropriate to provide for reduced or eliminated fees for certain eliminated individuals or entities in order to promote equity, fairness, barriers to so forth and so on. And that's fine.
Right.
I like that solution.
Yep.
How does anyone else feel? Nice solution, Peter.
That makes sense, given the first part of it. But the topic of B is circumstances when the agency shouldn't. That's the focus.
Right.
Sure.
All right, let's give that a look. Okay, Dave, it solves your concerns. Anyone else have any concerns with the new language? I don't see any hands. Any other edits for B? If not, we can keep moving down. Anything on C? I don't see any hands. For D, the new language that was put in there, anyone has any issues? Or any other edits that they'd like to add? On E, does anyone, I did want to flag that there is a provision in the code 31 USC 3701 that provides government debt collection authority. So is our thought here that we're thinking of supplementing that?
Well, that's in 3701, right? That's the
Yeah.
IOAA.
Mm-hmm. Yeah. So are we thinking of supplementing that, or did we think that that wasn't sufficient?
But this is for other statutes,
Okay.
right? isn't this is the list of things that are for other statutes going forward, so.
Yeah, so I guess making sure we're clear that they wouldn't just be referring to like, that provision, but creating their own provisions. And then I'm
Well,
fine
so
with
it-
it.
Yeah, I mean, one of the examples for that is in the report are agencies that are accepting applications. I mean, one mechanism is statutorily not approving any further applications, stopping any review of any pending applications if the company entity isn't paying their fees. Those kinds of things could be built in and would be consistent with E. I mean, I think that's some of the kinds of things that might be contemplated here. There was one agency that has a like a liquidated damages. Their
Mhm.
user fee payers have to pay like a bond in that is taken if the entity doesn't pay their fees.
That works for me. Anyone else for E, or we can move on to F. I see there were some comments here. Dave, let's see.
Yeah, I'm a little confused. I don't know if that comment was supposed to go there, but
I was not sure where that comment went either. So
yeah,
I thought this was the best place to put it, but I might be wrong.
I think it was originally up in paragraph 3, and I just don't think it was necessary at that point. So, I mean, yeah, this seems to be available only after appropriation is the same concept. So I don't. I think I might have had it inserted earlier. But I'm not quite sure what I might have been thinking if it was here. So moving on.
Okay,
Oh.
Peter?
Yeah, I mean, here we are back to my issue that we don't want to be too specific about. I understand. I think that the first sentence, the sentence could end after the word appropriation. And rather probably made available to the agency only after appropriation, period. And then leave out the whether there's reason to depart from this default rule. If Congress considers other alternatives, such as allowing funds to be directly available to agency for program expenditures, now it is not just the potential perception of bias and conflict of interest, it is also the means by which congressional control over the agency's action can be achieved. And that I understand that you might not want to say that, but to leave it as just a, well, you ought to think about whether they're self-serving over there, rather than you ought also to think about how are you going to achieve appropriate control over the agency when you've given up its when you've given them money outside of the appropriations process. I would be happy just to end the recommendation at the word appropriation and leave the rest implicit. But if one is going to talk about considering other alternatives, then it seems to me that one of the things that one has to talk about is the means for Congress to retain control over agency action.
Which we now say in the general consideration.
Yes.
Which we now say in the general consideration.
Do
Right. I'm
we-
happy to end it with after appropriation, period.
Yes. So we have like two potential solutions: end it after appropriation, or we could use the same language from the general consideration and just duplicate it down here.
Right.
Do people feel strongly one way or another? Whether we should duplicate it or just stop after appropriation? and making sure it captures our intent of what we were trying to achieve.
To clarify, you're talking about lines 62 through 64?
Yeah,
Yes.
I mean, if we're gonna have a section called general considerations that sort of overarches the rest of the recommendation, I don't think we need to repeat it.
right.
Yeah.
I'm happy not to repeat it.
I know.
And after appropriation.
Okay, so, and I see Dave there, your hand raised?
Yeah, just a question for Erica. Was there an element of transparency that you had thought was part of a needed recommendation in this area? I seem to recall something that in addition to accountability, that the transparency was an element of this issue of the availability of non-appropriated funds.
You know, I think it was more about the accountability than anything else. And there were some other issues like revenue stability that were part of this. I'm not sure transparency was a huge part, but there were several considerations going into it, more than just the constitutional consideration and the accountability consideration.
Thank you.
Okay, thanks. Peter, I see your hands up.
Oh, no, I've said my piece.
Okay.
Because I might be distracted by a furry creature that I have in the room. I could add when we get to H, rather than combine it with F above, I have problems about telling Congress, oh, you know, leave the money with the agency to just accumulate over time and spend whenever they want to.
Any thoughts on that from anyone else? Congress
Are
does
there
do it.
agencies,
So
are there agencies for which there are such
There are definitely
Yes.
agencies that have multi-year funds that rolls over and available until expended.
yeah,
Yes.
there are some that have the authorizing statutes, also the appropriating, language too. It does happen. It's not as widely out there, but it does happen. And others say, the authorizing language says it's going to be then subject, to appropriations in the annual appropriation.
So Congress should determine whether, if collected fund fees remain available to the agency until expended, reasons of oversight suggest constraints on those uses.
Well, then H becomes about something different. Right now, H
Yeah.
is about the time period during which the fees can be used, rather than the purposes to which they may be put.
Mhm.
Oh, I didn't mean to raise issues about the purposes. But should Congress determine that collected fees should remain available to the agency, comma, it should consider whether, for reasons of oversight, they should be available for a limited period. They should only be available for a limited period.
Okay.
is should Congress determine that for reasons of revenue stability, collected fees should remain available to the agency, it should consider. Should Congress determine. And then that for reasons of revenue stability, collected fees should remain available to the agency. Not whether, but that. And after the word oversight, whether.
So my one question on that, Peter, is the period of availability. I think you care about that, whether or not it needs to be appropriate, they need to be appropriated or they're automatically available to the agency, right?
Well,
This makes it sound like only if it's going, collected fees remain available to the agency absent the appropriation, or if it has.
I assume that's what this is about.
So I'll look to then Erica and Kasia. What were we? Was this one trying to be limited only to those agencies when they have, they don't have to rely on an annual appropriation?
Well, I think inherently that is the scenario we're talking about, right?
Yeah.
Okay, just making sure.
They're,
I better go take care of my beast here. I'll be back.
No, thank you. All right, so then I think this language works. Does anyone have any concerns with it? Let's give it a minute to think. Jeff?
I guess my only concern is that I think it's a little more common, and this implies that agencies have the ability to use funds in a multi-year period in various ways. I mean, they obligate the funds before the end of the fiscal year, but then they can continue to spend those funds on the project that they've obligated it for. There's a CRS report that just came out in February called Expiration and Cancellation of Unobligated Funds that details a lot of, it's only a 3-page little report here, but it has a little chart that talks about different language that Congress uses. Period of availability, expiration of funds, 5-year period, cancellation of funds. So there's a lot of different variations here. I don't know if we're capturing it all, but I don't want to make it seem like that funds from user fees are somehow should be treated in a more limited way than appropriated funds, or even vice versa. So I don't know if Erica's study showed any difference between the way user fee funds are treated as opposed to appropriated funds, but
no, I paid attention to the different ways that user fee funds were made available, but I didn't focus on a
Right.
comparison with appropriated funds
so
or appropriated taxes.
I don't know if this recommendation really points in one direction here, but
Yeah.
what does it say exactly? Can you accept all the changes on that one so we can see, just read it?
And Sid, are you jumping in to help us with this too?
Yeah, I wonder whether at the end of the sentence should only be available for a limited period or subject to other limitations.
Of course, that's in G also. Maybe we don't need G anymore.
I was trying to capture, give them a little more flexibility. If the only alternative to letting them keep the funds is you have to spend it in a specific period, that may not capture everything you were just talking about in the CRS report.
I'm gonna put this in the link or in the chat, just so you see
Yeah.
what it is.
Because being available for a limited period could mean many different things, right? It could be multi-year, it could be 2-year, it could be 5 years, it could be, but it means there's like an end date at some point.
But other limitations means you have to, as Jeff was just saying, attach them to a project and say you're going to spend it on this project. And so they just are not keeping the funds in the bank. They're
Yep.
dedicated to a project.
That's kind of what G's doing.
Although for some agencies, I think there's a thought that the funds should just actually remain available in case there's a shortfall. So a creation of a reserve fund that is just maintained.
Well, this allows that because it just said it should consider
Mhm.
as opposed to just keep them.
Is the or subject to other limitations meant to capture other limitations we didn't think of in G?
Well, it combines G, but
Yeah.
it ties it to this accountability notion.
Maybe we could switch H and G
Yeah, that
and then say any other authorizations.
Or prescriptions and take out limitations?
Maybe so.
Because that's actually, that flows nicely because that's focusing on the uses and not just the period of time of availability for H. Any other thoughts on this one? Anyone else? Anything jumping out at you?
Other in G, other requirements or limitations, maybe
sure.
at the end. No, the end. Or subject to other requirements or limitations.
Any limitations on the period?
I just
Well,
know that agencies in September try to get their contracts out so they can obligate the funds, and the contracts can go on for a while.
Well, that's when you have time limited money. But okay, so just looking at the first sentence for G is limitations on the period during which the agency may expend collected fees. By including requirements at the end, are we now out of alignment between the two?
Hmm.
And I see Carrie, your hand went up.
I was actually looking at H, and I wonder if we should say prescriptions for authorizations or prescriptions for instead of on.
Mhm.
It's a good catch. For the uses for which the agency. Okay, let's think about that one while we go back to my other conundrum. On the first line of G now, needing to align with the last sentence by adding.
Just omit the first line of G.
But every one of these
Has a little,
starts with a little thing.
looks like a descriptor of what that paragraph is about, right?
So then start with capital T, the period.
That works.
All right, nice edit there. Anyone have any thoughts on that or other concerns? So we can jump down to Carrie adding 4 on H. Any authorizations or prescriptions for the uses for which the agency may expend collected fees? I don't see any hands raised in objection or. If not, then I see we have Dave's got a comment on I.
This one was more just a broad comment to them, which I think maybe was addressed by the general considerations.
Yeah, that was originally with the language on bias and conflict of interest that was
Okay.
part of F,
Mhm.
and we struck that sentence.
So, well, good. We resolved it. Yay.
Hmm.
Any other thoughts and comments in I? If not, we could go. J, I think was pretty innocuous from before. Then we go to 6, Dave.
Yeah, this is up above. There was that question in the last paragraph of the preamble. There was a question of direct impact versus interested parties, and here I'm raising a similar question: stakeholder is a broad concept, and do we feel that it should either be narrowed or highlighted the need to consult with those who are most likely to be paying the fee?
All right. Erica, anything
Yeah,
from,
for sure. So I think the report definitely supports thinking more broadly about stakeholders, not just those who will be paying the fees, but also regulatory beneficiaries, if it's a fee assessed on regulated entities, other parties to whom the fee may be passed on, um, people, I think it very broadly, I think, at least in the report, the stakeholder community, I think, is pretty broad.
The people paying fees would obviously be stakeholders, and then there'd be other
For
ones.
sure.
So, potentially.
Yes. I would personally recommend that it be limited to pairs.
Right. No, the reason it stuck out at me was the edits at the last paragraph of the preamble. So when we
Right.
come back to that, we will address that.
okay, so should we put a pin on this one for this moment and then see what we end up with on the language to harmonize it to?
Yes.
Perfect. Okay, consideration for agencies. Let's go to that. Okay, someone's knocking on my office door. So sorry, everyone. Kasia, you want to keep running this for like a second so I can figure out what someone thinks is an emergency happening right now?
Yeah, sure.
Thanks.
Okay, I'll just keep going. New number 7. We didn't have any submitted comments on that, but I'll give everybody a second to reread this, and feel free to raise your hands if you have any comments on this. New number 7. All right, seeing none, I guess we'll go to new number 8. Carrie, I know you had a comment on this. It's quite minor, just adding the S at the end of purpose, which was consistent with another recommendation on here. Sid.
I would consider adding, after identifying and explaining the fees, comma, the availability of waivers or exemptions.
Oh, is this in, what line is this?
Oh, I thought we
140?
were in, 8,
Okay, so new number 9, so.
now 9, yeah,
140,
right there, yeah. The availability waivers or exemptions. That goes both to equity, and that's the thing the user would want to most know about. Can I get an exemption?
sure. I'm also gonna call on Carrie if you wanna, just talk about the comment that DOT submitted here.
Sure, I thought that someone might see accessible and think of section 508 compliance for websites to be accessible to people with disabilities. And I was trying to think of another word that might capture what I think the intent is, that the information about user fees would be easy to find on an agency's website. So I don't know if prominent is the case, or excuse me, easy to find, if that's too simple, but something to avoid accessibility, leading someone to think of 508 compliance.
Helen, I see you're back. Is everything
Thank
good?
you. Yep.
Okay.
Sorry, this is what happens when you work in the office. People actually knock on your door.
All good. So Carrie was just talking about the accessibility, I shouldn't say issue, but the use of the word accessible causing some confusion. So just changed it to
Or easy to find, maybe
Yep.
would work.
Yep. That makes perfect sense. We don't want to confuse. Not that accessibility is not an important issue, but that's not what we were aiming at here. Anyone have any issues? No, thank you, Carrie. Any other, so we're on paragraph now 9 then. Any other comments on 9? If
Do
not,
do you think that documentation is the best word, or would something like resources be a little broader if it's like the website section?
I like resources. What do other people think? Well, resources, it looks like 1 carries. All right. Excellent. Anyone, any more for, and or we go down to 10? This is the retrospective reviews. Jeff.
The word adequate. The fees are adequate. Is it appropriate or proportional, or some of the word that we were adequate makes it seem like we're concerned that they're too low, which we might be, but we might be also concerned that they're too high. So.
Okay, good catch. Now I'm looking to see how either Erica or Kazia or Jeremy or anyone else.
Appropriate.
Yeah, I think we want appropriate, or we're back in the issue of that we
value judgment.
dealt with before about users and
Right.
charging more and all that.
All right. I like appropriate. Anyone else have any thoughts or? I don't see any. Thank you, Jeff. We can then we can go to the meat of the, the text at the very beginning. So. All right. Dave, you had a comment? Let's see here.
Dave, correct me if I'm wrong, if this is in the wrong spot. I know your comments were just kind of on the page in general, so I want to make sure that it was in the right spot. He may have stepped away for a moment.
That's okay. We'll get back to him when he gets back. So
I'm not sure whether that's an accurate statement. I mean, just think about all of the agencies that maybe this is just in the evil past, all of the agencies that were captured in effect by those that they were ostensibly regular, that they did regulate. And those were regulatory programs that provided considerable net benefits to the regulated entities. It's the way in which the Fed is set up. Similarly, I don't think it's a rare regulatory program that provides net benefits to the regulated entity.
I think that the important point is that in order for there to be a fee that someone has to pay in order to get a license to operate, the first thing the federal government has to do is prohibit that activity in the absence of a license or fee. Regulated entities do not look upon the fees that they pay to support regulated programs as a benefit, even though by paying that fee, they get permission to operate, because they see that in the absence of that program, they would be operating anyways.
Well, the drug companies were the ones that wanted the FDA to use a user fee program so that their applications would be handled more quickly. So they lobbied for it.
Oh, absolutely. They certainly did lobby for it, but they lobbied for it because the first thing that happened was they were prohibited from marketing without FDA approval. Yes, I get that there are some out there where there is absolutely an impression that what happens is you pay the government and they give you permission to operate. But I'm not completely sure that characterizing them as these users benefit, registration fees for SEC, have fees for chemical reviews under TSCA. These are not fee-for-service programs. You are regulated by the federal government and you will pay in order to keep operating. And
Right. And of course, this is the reason why, if you go back through the history, a lot of these agencies, FDA, for example, didn't assess fees under the IOAA initially because they perceived that statute as interpreted by the Supreme Court as not allowing them, in part, this was one of the reasons, not allowing them to assess a fee if most of the benefit was for the public, and there were questions about the amount of benefit, if any, that the regulated parties got.
But my parenthetical comment aside, my proposal is the language that Kasia has put into the red line strikeout, and that was collects a fee from an entity engaged or seeking to engage in a regulated activity. I think that captures the range of the activities that we intend to at this point, without telling the regulated community that they are so lucky to be able to pay these fees.
I don't have a problem with it.
what? We're not making a value statement, Dave?
That you confuse costs and benefits with obtaining a benefit. And this is obviously to distinguish it from someone who is obtaining, say, a benefit from the federal government by filing a filing fee to get an EBT or a grant.
Okay, Erica, does it capture what you were thinking of as a definition?
It's different from the definition. I'm taking a photograph of the screen, so I keep that. It's not the definition that I adopted in my report, but it might actually work better than the one I adopted. So I'm not sure. So yeah, I think it's fine. I need to think about, if I change what I have in my report, then the footnote's fine.
Yes.
Otherwise, if it departs, you'll have to move the footnote.
That was gonna be my question,
I-
so thank you.
I take it, Dave, that though that you do not object to the sentence that follows, that talks about user fees that shift the costs of the program to those whom the program benefits most directly.
Well, right, and because I see that as not applying to that second sentence, because as Erica mentioned, these are fees that don't provide the benefits most directly to the people paying the fees. The benefits are accrued, to those folks who are protected. I mean, SEC registration fees. They're a user fee, but there is no benefit accruing to the registrants, right? The existence of the SEC does not protect the registrants. The existence of the SEC protects the investors who invest in those companies.
I'm not objecting at all to the other clauses in this
Right.
Yeah.
last sentence. Just pointing out that the sentence does speak about shifting the costs of a program to persons or entities whom the program benefits. And that seems to me entirely appropriate.
Yeah, I think that applies to the first clause, just not the second clause. I think
Yeah.
the second two apply to the second clause.
Yeah.
Okay,
fine.
great. And
Yes.
I see Sid's hands up. Thank you, Sid, for your patience.
In the recommendation, we took out the words most directly. So unless we want to go back on that, we probably should take it out here.
Good catch. Yeah, so line 6.
Yeah.
Yes. Thank you for that catch. Great. So first paragraph, any other edits, thoughts, concerns before we move to the second paragraph? Starting on line 8.
Second paragraph.
Yep, Jeff.
This is really minor, but when I read the first sentence, I was expecting the next sentence to say something about Alexander Hamilton or Benjamin Franklin or something. But I think to just make the transition a little better, put in 1952 at the beginning of that sentence. In 1952, Congress enacted, and it's kind of clear we're just skipping ahead.
Yeah.
Right.
Okay. That's all.
Not that we have anything against Ben Franklin.
Probably did something with the postal service. He sold stamps, right? The user fee.
Excellent.
Well, by that metric, aren't tariffs user fees since it grants permission to import into the country?
Yep.
Custom service. Mhm.
Yeah. All
Maybe a
right,
little bit more tricky to write that recommendation though.
yes, indeed. Third paragraph, starting on line 16. Dave, I see you have an edit here or a comment.
No, that comment applies to the paragraph starting on line 26.
Oh, okay, good.
Okay, thanks, sorry.
Thank you. Then the next paragraph starting on line 21. Is there anyone have any? There. Oh, thank you for blowing that up for my old eyes. If not, we go to line 27, which is where your comment goes, Dave. Is that
Yes, it goes with the sentence that starts on line 32. No, sorry. Yes, line 32, which is, I appreciate the contrast, but it's a repetition of the definition above. So it seems to be superfluous. There might be a point underlying it as, to emphasize the bifurcation of the definition, but if that's the case, it doesn't belong in the middle.
Sid, are you on the same comment or something different?
Different.
Okay, I'll hold on for a second. I'm looking to our drafters. Any issue with taking it out? Nope. Okay, let's take that out. Thank you, Dave. Sid?
First sentence, vary significantly in their structure. Would a better word be vary significantly in their authorization?
I like
Maybe
it.
design? Oh, okay, never mind.
Oh, no.
In their terms,
I was thinking design in part because that is 12 terms, maybe.
Well, we do say
D-
program
design is better.
designers.
Uh,
Yeah.
Oh,
Yeah.
I'm just trying to get rid of the word structure. Design's
Yeah.
fine.
Yeah, I like design too, because then it flows with
Yeah.
how the rest of the report recommendations. So. Thank you, everyone. Any other comments on this paragraph? Give everyone a moment to read it. So let's line 37 where it says other statutes may also provide rules. What if we said other statutes also impose legal requirements that would apply to user fee?
Or just requirements.
Or requirements, yeah.
I'm just confused about the conditional in that sentence.
I would say just also to take out the may, yeah.
And even the would.
Mhm. Yeah, I guess the only time there might be a conditional is if Congress explicitly exempts a program from one of these ones. So it's a good catch, Dave. Any other thoughts on this paragraph? If not, we have Department of Transportation on line 41. Carrie?
So I think this is the only place in the draft recommendation that policymakers appears, and program designers, which is used in the next paragraph of the preamble, and in some of the specific recommendations is more common. So Eric, I think will know best, but I pulled a couple of places where the report speaks to the terms used, but the suggestion is that if we mean program designers and policymakers to be the same group, consistency probably with program designers might be helpful. And if they're different, then that, that's fine too.
In the report, program designers was meant to be either congressional or agency level people designing a user fee program. Policymakers was only a reference to legislative actors. So I think that, in other words, the report adopted a very specific approach that is not being tracked here.
I don't think we need to hyphen an executive branch.
Good catch. Program designer works. Any other thoughts on that? It's a good catch, Carrie. Karen?
Just executive branches. Independent agencies don't design.
They're in the executive branch.
Karen's going to tell you why the FCC is not.
It's got to be in one of the three branches.
Consider it said. We are in a weird fourth cloud area where depending on what in particular you are talking about, it either does or does not apply to us.
Well, we do say, I mean, we do say federal agencies and agencies throughout the document. I think this is the only time we actually say executive branch.
Why don't you just shorten that sentence completely by eliminating all that first part and just say user fee program designers must also consider.
Yeah. Sorry, Karen, you're back in. You thought you were getting out of this report, but no, you're back in. So. No, this is good. Any other thoughts on paragraph starting in line 41? I had one thought when we talk about the impact on the fees on low-income people and members of historically underserved communities. I know small businesses and fees, there's a big correlation of concerns with that too. Do we think this captures small businesses in there? Or
I'm sorry, yeah, I at some point that might have gotten moved around. Yes, I had sought to insert after historically underserved communities, small businesses.
Oh, perfect. Thank you, Dave.
It's in the next paragraph now. That's where you inserted it.
Yeah, it looks like we had a cross signals on what I had sought to insert. Oh, that's right.
Oh,
because
okay, you put it below.
it's
Okay.
I have a PDF and I can't actually insert into anything into a PDF. That's why. So
Okay.
yes, that it was Kasia, best attempt to understand my chicken scratch, right?
Do you want me to keep your addition here too as well, or no?
Well, I think we need to have the conversation about what that potentially impacted. Because down below we say stakeholders, right? And here we say potentially impacted parties, presuming we're talking about all entities, individuals and other entities. And I guess I wasn't sure, since I missed the last meeting, what the intent of changing interested persons to potentially impacted persons reflected in the committee's consideration. And that's why I again go back to just the term stakeholder down below. Do we mean this to be program designers need to engage with stakeholders, with interested parties, or are we trying to call out a particular obligation to consult with those who are going to be paying the fees?
Yeah. And Erica or Kasia, what was the intent in the drafting here originally, or in the record, in the report?
I think it's the same consideration that we had in the one where we did get rid of stakeholder, or not down here. Yeah. Yeah, that one. So I mean, we could use stakeholder, but like I said, it's up to the committee. I think it was initially in line with that thought.
Is it really, we're really thinking of the people that would be paying the fee, that their input is particularly important?
I think it's broader than that. I think it's the people that are also affected by the fee, if they're not paying it.
You see, that's sort of the weirdness of this, right? Because presumably these are on the regulatory side, presumably these are regulatory programs that exist in the absence of the fee. And the fee is the means by which, as you know, Jeff brought up within FDA, the fee is the means by which the payers of the fee might, you know, prod the governmental mechanism into faster or better responsiveness, but the program exists nonetheless in the absence of the fee. So is it really those who benefit from the program, that is the non-payers, or is it truly there is a special obligation to consult with those who are going to be paying the fee, presuming that the regulatory program exists in its absence?
Well, so the report certainly supports saying that there's a special there's an obligation to talk with all of them, in part because the payers, who are the regulated entities, may pass the cost of the fees on to, an example of FDA, consumers of their products, who would then have an interest in the fees, or Public Citizen, which was one of the groups that I interviewed, and their position is that they, as regulatory beneficiaries, have an interest in the design of the program, or as representing regulatory beneficiaries, have an interest in the
Of
design
course.
of the program because of concerns about capture and so forth. So I think it's, at least the report supports engaging with a broad array of stakeholders, not just the payers.
Okay, and then, so Peter, I see your hands up.
Go ahead.
I've got to leave, but I want to recommend now deleting footnote 6, since we've introduced that consideration into the general considerations. And I don't know that the footnote otherwise.
Okay. Anyone object to footnote 6 being deleted while we're thinking about what we're doing with interested, potentially impacted persons and stakeholders?
Well, there is a constitutionality point that we're not talking about.
Yeah,
Maybe the
yeah.
footnote should just be limited to that.
Well, but it's in the general considerations now.
No, I
Hidden, so somewhat hidden, but it's there.
it may be worthwhile maintaining the second clause of footnote 6, just to emphasize that ACUS is not weighing in on the constitutionality, even though it presents that as an option.
Like the CFPB case.
Yeah, that's a good point.
Can I see the text as your? No, that's all right.
Okay. Thank you for finding a solution, Dave.
And this has been terrific. I've got to leave you now for
Thank you.
another engagement, but thanks for all.
Thank you, Peter. Go have fun trick-or-treating. Just kidding.
No, not.
Jeff, you've been patient.
Oh, so we're still talking about that last paragraph of the preamble.
Mm-hmm.
Okay, so I guess I had two questions before we started. But one is, I don't like the word impacted. I mean, impacted persons. It sounds like somebody who's gotten, run over by a steamroller or something. I mean, how about it? Is affected not good enough there? Potentially affected persons, and that's my one little problem there. And the second is, I'm wondering, do we think that this recommendation supersedes recommendation 87-4? I mean, is there anything in 87-4 that we're trying to keep? I mean, this is kind of an ACUS, institutional question, I guess, maybe for Jeremy, but if we're superseding it, if we don't want people that bother to go back and look at the other one because it's not necessary anymore, we should say that. That's just a general question. Now, the other things about this paragraph that we just went through some of the same questions in the previous paragraph. So I don't know if we need to repeat. So we still have in congressional executive branch with a hyphen program designers here. And we also have the same and small businesses and other small entities. So it seems like we're trying to summarize in this last two sentences of this paragraph, why we're doing this recommendation. And this is the sort of nutshell of it here. And do we need that? If we need it, then we should make it consistent with the previous paragraph. And if we don't need it, we should just stop at where footnote 6 period is.
That's a good observation. I was going to say that the last sentence talks about public engagement. So are we, and basically both of them try to capture public engagement. One's public engagement, calling out affected persons and small businesses, and the other one's more generally public engagement. If we took out the sentence in particular and then just kept the conference, and then we take the concept of public engagement that we have in the last sentence, does that capture the broader public engagement concern? Like, are we losing anything? Like, did we specifically want to be calling out specific parties of the public, or is public in general what we're aiming at?
Well, very last,
You'd
two
have to now
lines are-
massage it a little bit if you kept just the one. And
they're really general. I mean,
Yeah.
The last part, we're not tying that to
yeah, you'd have to.
user fees.
So then it'd be like, the recommendation encourages, let's see, program designers to meaningfully engage with the public, comma, as they design, and then the conference supports it. I just want to know how generally we want to keep the public. And Sid, you probably have a solution to all of this, as you've been patiently having your hand up.
Yeah, it was to eliminate the sentence. I don't think we want to be in the business of saying some people ought to get more access than others. And because they already have it. So I think this is an elegant way, and we've already set up in the previous one, you ought to talk to all people who might be affected. So I don't think we lose anything by getting rid of the sentence.
We lose the footnote.
Dave,
I was going to suggest taking that sentence, that last sentence of the paragraph, and moving it to the end of the previous paragraph.
Right.
And maintaining these last two sentences, the two remaining sentences as the summary. And that ties the potential for public engagement to these historically underserved and small business communities, even if it isn't necessarily said that they deserve additional access. We're linking those two by talking about impacts and outreach.
I like
I like that. How does everyone else feel about that? I hear no nays to this. It's an elegant solution.
So what about the previous recommendation? Is Jeremy still on the call?
Yeah, I'm here. I mean, it's a
What do you-
great question. It's a great question. I mean, I think it's ultimately up to you all to decide. I think certainly this recommendation is broader and touches on subjects the previous recommendation didn't. And I think certain definitions vary in some ways. So maybe I turn it back to you. And maybe Erica, can I turn to you in the first instance? Do you have thoughts on how this relates to the earlier recommendation? Should it be read in tandem with it? Should it supersede it?
To some extent, it can be read consistently with it because there's a express reservation in that earlier recommendation, as I recall, that it was not taking into account. It focuses on designing user fee programs to accomplish economic efficiency, and it explicitly sort of carves out the other possibilities. So this, for other purposes, other design. So I think this isn't inconsistent with it, but it's certainly much broader in scope. I don't think we'd have to rescind or anything like that. I mean, I don't think there's a inconsistency, but I think this, in a sense, becomes the new definitive thinking on the issue because it's broader.
Well, then why don't we just say it supersedes it? I mean, it's not, we're not rescinding anything. We're just saying that this is an updated version of that recommendation, and we're telling people they don't need to bother reading both of them. This is the one they should read.
Do
And
they,
the
is-
earlier one's quite short, by the way. It's only like 2 pages.
Yeah.
Doesn't say that much.
do we lose any? There's nothing in it lost if we say we supersede it.
I'll throw a link to it in the chat if people want to see what it says.
Thanks, Jeremy.
It does talk about directly benefiting fee payers, and it's a benefit to the fee payer where it confers an advantage on the fee payer.
It's really limited to the more narrow sense of a user fee, not the kind that is assessed against regulated entities to support regulatory programs. That kind of user fee just wasn't part of the underlying report.
The advantage of supersedes is it does make it clear that if there are inconsistencies, it's this report that the conference is now endorsing.
Well,
If
I wonder
if they're
there's any-
consistent, then they're consistent.
I wonder if there's anything in the old one that maybe should be imported into the new one then. Might be good to put it up on the screen for a second, just this,
It has like
because
looking
I,
market
know.
and cost considerations.
well, for example, I see one paragraph in here, it's called other considerations. And it says, where third parties or the general public benefit significantly from a governmental service, user fees need not be set to recover fully the costs of providing that service. Agencies should consider the practicability of allocating costs between fee payers and others when determining the proportion of service costs to be recovered by user fees. I mean, that's a slightly different twist on what we were talking about before. So there are a few things in here that maybe, I mean, it would be nice if we could just sort of import them in there into ours, but that might take more than the 15 minutes we have to do it. But if you look, especially at page 2 of it,
What if we said something like it supplements and updates? So like something that captured that, sorry. For anything that conflicts, the newer recommendation is the authoritative one.
this isn't the first time that the administrative conference has updated a previous recommendation, and normally we don't say anything about it. But in this case, I think it's been a long time. There have been revision of circular. You say a lot more here.
I'd love to hear the outcome of this, but I got to go teach.
Thank
But
you, Sid.
thanks, everybody, for the constructive work on
Thanks.
this.
Thank you. Any other thoughts of ways we can massage this? Does that reflect what we think we're doing?
Where is it now?
It's at line 53, 54.
I will say that the earlier, I mean, obviously the ACUS, the only thing ACUS has is its recommendation. The underlying report in 87 was very much focused on just economic efficiency justifications for user fees. And so this current recommendation is cast much more broadly because it was supported by a report that cast was
Yeah, we don't have to say
scoped more
anything about,
broadly.
we don't have to say anything about the earlier report.
Right, obviously.
So I guess that captures it pretty well. It just doesn't use the word supersedes. So maybe we don't need to use that word, but I think it gets our point across that this is the updated, new and better version. What do you think,
Okay.
Jeremy?
New and improved, I like it.
New and improved?
So do we need to go down? Was there one more spot in the language where it talked about stakeholders? Are we still? I want to make sure there we go. Public input?
I think stakeholder input definitely includes the fee payers and could include other people. So I think it's better.
Okay. Anyone have a issue with keeping stakeholder in this instance?
I think it's better than the generic public input.
Yeah, no, given the edits above, stakeholder works fine.
Perfect. Do we have any other remaining edits that were unresolved? Comments or concerns by anyone?
What about the title?
User fees? You didn't, what, the most succinct title ever? You don't like that?
No, it's fine. We just haven't talked about it.
Okay. Is there any other?
User fees redux.
2.0?
Yeah.
No. Does anyone else have any other edits or suggested changes or concerns with any of the language? Do we need to vote on anything? Remember, this is my first time doing this.
One question is Erica's, is this your final report, or are you going to do
No, that's a draft report. The final one will be done in a couple more weeks.
so first footnote will probably need to be adjusted for that.
Mhm.
Yes.
Yes, I have a note for that. So Erica, you and I will touch base on that.
Okay.
But Helen, otherwise, if there are no more comments or edits, I believe it would be time to call for a vote.
All right, let's call for a vote. My first vote with everyone, yay. So we are voting on, what are we voting on? Where's the recommendation itself? I'm looking to, who can vote? Yeah, and who can vote?
Is everyone that is on the committee, or the alternates of those on the committee?
Okay, so anyone who is on the committee or their alternative, if you do not know, raise your hand and we will figure it out for you. If not, everyone who supports in favor of the regulation, raise your hand, say aye, raise your hand. Oh, I guess I should raise my own hand. All right, has everyone raised their hand? Great, then we can lower anyone who opposes. Phil, are you an oppose or a support? Just making sure. Oh, okay, gotcha. Anyone who, okay, next up, anyone who opposes or nay for the draft recommendation, raise your hand. I take it the ayes have it. Fantastic.
I suspect Sid and Peter were in favor of it. They seemed to indicate that when they left.
Are you voting in abstention for them, Jeff?
I'm trying to.
Fabulous. So I think we have the ayes have it. Fantastic job, everyone, working on this recommendation. I think the outcome is really great. So thank you for all the thoughtful input on it and coming to resolution on any of the questions we had. Anything else we need to do? If not, do we close this session?
I think we're all good. I will clean all this up and circulate the final committee approved recommendation, and obviously we'll update footnote 1 based on Erica's final report. So that'll be the only thing flagged, but otherwise, great job, everybody, and really appreciate everyone's participation, and happy Halloween.
Yes, happy Halloween. Thank you, everybody.
Thank you.
Thanks. Bye.
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 Bye.